Chairman Chaffetz, Ranking Member Cummings, and members of the Judiciary Committee, thank you for holding this hearing, and thank you for giving me the opportunity to come and testify before this hearing in support of the First Amendment Defense Act. It's an honor to be here and to participate with my fellow witnesses on this important discussion. I'd like to preface my remarks today by issuing a challenge to all those who are involved in this debate here on Capitol Hill and, for that matter, across the country, myself included, as we engage in dialogue with one another about this topic which happens to be highly charged. Let's commit to treating one another with respect, with kindness, and with decency, as fellow citizens rather than as adversaries. Let's insist on hashing out our honest differences honestly. It's too easy to assume the worst in those with whom you disagree, to impugn their motives so you don't have to listen to their arguments. Let's be better than that today. We all came here to talk, but let's not forget to listen just because we're here to talk. And with that, I'm going to spend a few more minutes talking now. The most important feature of this legislation, which I was proud to introduce in the Senate, the First Amendment Defense Act, is its exceptionally narrow scope. If enacted, the bill would do one thing. It would do one thing only, just one thing. That is, it would prevent the federal government from discriminating against particular disfavored religious beliefs. There are other forms of discrimination in the world. For instance, the discrimination that may occur between two private parties, two people who are not the government. But these are entirely different issues, and those types of actions are completely unrelated to and unaffected by the First Amendment Defense Act. This bill deals exclusively with a particular but a rather pernicious form of discrimination, one in which the federal government could single out certain religious beliefs for disfavored treatment. The bill is so narrowly focused because it is a targeted response to particular legal developments that have taken place just in the last year or so. In the wake of last year's decision by the Supreme Court in the same-sex marriage case, Obergefell versus Hodges, many millions of Americans were left wondering, what does this mean for me? What does this mean for me personally, for my family, for how I live my life? There were many who wondered what the court's decision might mean for countless institutions that play a significant role in our civil society, including churches and synagogues, charities and adoption agencies, counseling services, and religiously affiliated schools, colleges, and universities that are made up of American citizens who believe marriage is the union between one man and one woman. For instance, now that the Supreme Court had discovered a constitutional right to same-sex marriage, would a school that holds the belief that marriage is the union of one man and one woman be in danger of losing its tax-exempt status? Would it be deemed no longer performing a charitable function simply because it had that religious belief? More than 1 year after the Supreme Court's ruling in the Obergefell case, these questions remain unanswered. On the one hand, the court's majority opinion in the Obergefell case reiterated the meaning of religious liberty that has always been understood in America when it stated, quote, "The First Amendment ensures that religious organizations and persons are given proper protection as they seek to teach the principles that are so fulfilling and so central to their lives and faiths," close quote. But on the other hand, there was the ominous exchange referred to by Chairman Chaffetz a few moments ago between Supreme Court Justice Samuel Alito and Solicitor General Donald Verrilli during oral arguments in that case that seemed to suggest that the Obama administration would be comfortable with the notion that the IRS could revoke the tax-exempt status of religious institutions, including schools, colleges, and universities that maintain the traditional definition of marriage. The First Amendment Defense Act is a very narrow and very targeted legislative response to these questions, to these still unanswered but nonetheless very important questions. The bill reaffirms the letter of the First Amendment. It also strengthens the spirit of the First Amendment. And it does so by stating unequivocally that the federal government may not revoke or deny the federal tax exemption or any grant or contract, accreditation, license, or certification to any individual or to any institution based on a religious belief about marriage. The First Amendment protects each of us from punishment or reprisal from the federal government for living in accordance with our deeply held religious and moral convictions. Adhering to these convictions should never disqualify an individual from receiving federal grants, contracts, or tax status. What an individual or an organization believes about marriage is not, and never should be, any of the government's business. And it certainly should never be part of the government's eligibility rubric in distributing licenses, awarding accreditations, or issuing grants. And the First Amendment Defense Act simply ensures that this will always remain true in America, that federal bureaucrats will never have the authority, the discretion to require those who believe in the traditional definition of marriage to choose between living in accordance with those beliefs, on the one hand, and on the other hand, maintaining their occupation, their tax status, or their eligibility to receive and obtain grants, licenses, or contracts. The First Amendment Defense Act is absolutely critical to the many charitable and service organizations in this country whose convictions about marriage are fundamental to their work and to their mission. Guaranteeing the full protection of these organizations' First Amendment rights will ensure that faith-based adoption agencies are not forced to discontinue their foster care and adoption services on account of their belief that every child needs a married mother and father. It will protect religiously affiliated schools, colleges, and universities from losing their accreditation or being compelled to eliminate housing options for students. And it will protect individuals, regardless of their beliefs about marriage, from being deprived of eligibility for federal grants, licenses, and employment, simply because of their deeply held convictions. Now, you may hear tall tales, and in some cases perhaps outright falsehoods about this bill, about this legislation we're discussing today. Some may suggest that the First Amendment Defense Act, or FADA as we sometimes call it, would give private businesses a license to violate anti-discrimination laws with impunity. This is just not so. It isn't true. The bill does not preempt, negate, or alter any anti-discrimination measures or civil rights laws, state or federal. To be clear, this bill does not take away anything from any individual or any group because it does not modify any of our existing civil rights protections. The First Amendment Defense Act does not allow federal workers or contractors to deny services or benefits to same-sex couples, and it does not allow hospitals to refuse medically necessary treatment or visitation rights to individuals in same-sex relationships. I invite everyone within the sound of my voice to read the bill so you can see in plain English, in black and white, that the First Amendment Defense Act does not do any of these things. It simply reaffirms all Americans' God-given, constitutionally protected right to live according to their religious or moral convictions without fear of punishment by the government, especially when it comes to operating churches, schools, charities, or businesses. It recognizes that religious liberty in America has always meant that the government's job is not and can never be to tell people what to believe or how exactly to discharge their religious duties, but rather to protect the space for all people of all faiths and people of no faith at all to seek religious truth and to order their lives accordingly. Questions surrounding marriage today are difficult, and reasonable people of good faith will reach different judgments about how best we can protect religious liberty. But the First Amendment must remain our lodestar, and I believe any differences of opinion can be constructively worked out, even and especially as to particular provisions of this bill, if our shared concern remains preserving the American tradition of religious liberty. I hope it is. Thank you.